Yeah, well, I'm trying to read my hand. I'm trying to make sure I give the possession of drug-like objects UJRs to the jail.
Okay.
I'm trying to figure out where they're at. Let's see. All right. So we got 25, 25, 25, 25.
25,
UJR jail 20, 20, and
75,
1,000. 25, 25, 25, 25. UJR jail
100,
20, 20, and 1,000.
over 100,000,
Got that, Mr. Robinson?
126,000.
Got it.
Yes, Judge, I did.
All right. Best of luck to you, sir. You can leave the booth. Let's see. Jarvis Ruckamore. Miss Ruckamore, all right. Mr. Walker, this is number one. 23 CP 218753. 90 days without indictment. No bond as of May 24th. So that's aggravated assault, cruelty in the first. Pre-trial.
Extensive criminal history, multi-state offender. Well, not extensive arrest history, but multi-state. 3 in Georgia, 7 in Tennessee, 1 in Mississippi, 2 in Wisconsin. Tennessee, there's a prior domestic assault in 2014. In Wisconsin, there's a vehicle operation scheduled 1 in 2015. There's an FTA in Georgia. Nothing further.
All right. Go ahead, Mr. Walker.
Perfect.
Judge, I've been on Mr. Rockamore long time. Went to school with his brother. That's how I know him from Wisconsin. They residing in the state of Georgia for the last 10 years. He has 2 children, a 10-year-old and a 3-year-old. All this, that's what this incident stemmed around. Situation with his daughter at the school. What we asked the court judge is for a bond not to exceed $25,000, because according to our investigation, it definitely didn't happen the way the state told it when we was in front of Judge Wolf.
All right. What says the state?
Good morning, Your Honor. ADA Travis Thomas for the state. Your Honor, I just want to clarify some things. First of all, the criminal history. There's 1 FTA here in Georgia in May 23rd, May of 2023. I'm also showing another FTA in Tennessee on April of 2013. Furthermore, Your Honor, the offense in Wisconsin 2015 was actually a fleeing and attempting to elude from the police officers there. Your Honor, because of this extensive history and the fact that this is an incident that included waving a weapon at kids, I would ask that bond be denied in this case.
It's been 90 days, so
And Judge, I can tell you this, Judge, that is a lie. My client, according to the witness who is the bus driver, my client did not have a gun. He never got out the car. It's amazing. I'm surprised that they.
It's a lie.
Now the witness said my client didn't have a gun. The Mexican, Hispanic American man.
A Hispanic, a Mexican American man.
Got out the car. His wife was there and his daughter.
I don't know how this relevant,
So
sir.
if y'all indict the case, Mr. Thomas, we can go ahead and drop a speedy and get rid of this matter.
Okay, that's definitely within your right, Mr. Walker, but Your Honor, I'm
It's not the time to litigate that, sir.
and what the warrants say. So,
Well, we have the witnesses that y'all didn't talk to. We got witnesses.
I would ask that I would ask at least 50,000 for the cruelty to children, and at least 25,000 for each aggravated assault, for a total of $100,000, Your Honor.
all right. No drugs unless prescribed. No alcohol. No weapons. Stay away. Does he live? He lives in Fulton County, right? He doesn't live at the Lakeland Drive.
Oh, he lives in Fulton County? Oh, he's screwed.
No, ma'am.
Okay. Stay away from 50 Lakeland Drive. No further contact with GELIN Cruz Flores and Luis LUIS Cruz. Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer. Good luck to you, sir. You can leave the booth.
Thank you, Judge.
Thank you. Have a good one. All right. Rondon and Bostic, 23 CP 219025. Kavian Thomas, 265 days, not on this charge, though, on other counts, other cases he has. Without indictment, he's got aggravated assault and riot in a penal institution. Pre-trial.
Empire Cycles, open case 23 SC 186720, firearm by theft by receiving Mr.
and that does include his child. Mr. Thomas has an 11th grade education, and prior to his arrest, he was working in construction. He does have a good address. It is the address, I believe it's the one on file, the Newcastle Circle in Stonecrest, where he would reside with his mom. I would ask for bond to be set in this case, Your Honor, and I would ask for $10,000 on count 1 and $5,000 on count 2.
All right, what says the state?
Your Honor, the state would be asking for a high bond in this case, no less than 80,000. The state is concerned with this risk to reoffend with these personal offenses while the defendant is in incarceration, particularly those offenses Madam Pretrial stated, but 220987, and then also the recent personal offense that he had that I believe he had a battery for. Just the amount of personal offenses involved involving the defendant at the jail gives the state significant concern and risk to reoffend, endangers the community if he was released.
That's the end of the world.
Released.
All right. So I got no drugs unless prescribed, no alcohol, no weapons, no further contact with Derodney, Derodney Russell, Russell, and commander paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay out of Fulton County unless you're for court or to see your lawyer. Absolutely no other reason for you to come to Fulton County. You understand?
No McDonald's, no Taco Bell. No
All right, he
Buffalo
nodded
Wild
in the
Wings.
affirmative. 20,000 count 1, 5,000 count 2. Best of luck to you, sir. You can leave the booth. Back at you. All right, Jermaine Davis. No Jermaine Davis. Ramadan Salim.
Ramadan. That's
Thank
best
you, sir.
name. I appreciate
see.
it.
Position
That's
6.
my case, Judge.
All right,
Yeah.
position
So I
6.
totally
23 CP 218-820. 89 days without indictment. No bond as of June 3rd. Driving, fleeing, and attempting to elude. Too fast for conditions. Prima facie speed. Driving in an emergency lane. Improper erratic lane change. Reckless driving. Driving license suspended or revoked. Failure to obey traffic control devices or stop signs. Aggravated assault against a law enforcement officer while engaged in official duty. Aggravated assault against a law enforcement officer while engaged in official duty. 2 counts of possession of a firearm by a convicted felon. Pre-trial.
Trial.
8 prior arrests, 1 misdemeanor, 2 less than probation violation, felony conviction, 06 Act battery, nothing further.
All right. Go ahead, Mr. Harvey.
Don't know.
Hey, good afternoon, good evening, Judge.
Jeez,
Mr. Salim is 37 years old. He's been raised in Atlanta his entire life. He's got 2 children, one 7 months old,
Not
one
surprised.
7 years old. He's got his parents who live here and support him and would support him. He's got his wife who is on, I believe I saw her monitoring this hearing. Her name is Zakia, and she lives with Mr. Salim and obviously helps to take care of the children. He would live at one of 2 addresses, depending upon your honor, 2850 Leisure Springs Circle in Decatur, Georgia. That's where he would live with his wife and children, or 1389 Lucille Avenue, Atlanta, Georgia, with his mom and dad. His dad is 78 years old. He helps take care of his dad. You can see him in the booth at 7N. As a result of this incident, he was shot. He has lost an eye. He was in Grady. He had extensive medical treatment in Grady. I went to visit him in Grady. He is now at the worst place in the United States of America where somebody just died this weekend. And he needs professional medical care. He also has, excuse me, he's got a job, a confirmed job at Chance, the #1 boxers. It's a boxing industry. I've got a letter saying he's got a job waiting for him, and that would be at 2730 Sullivan Road, College Park, Georgia. That's from the owner and CEO of that company. I've got a letter, and I can scan and send all these letters from the resident imam that that counsels inmates at Fulton County, and that is Imam Furqan, Furqan. He's the resident imam, and he has been counseling Mr. Salim since his incarceration at Fulton County. So I've got letters from an employee. He's got employment. I've got letters from the imam who's been counseling him. I got letters from his parents. He's got a job. He's got a place to live. He's never failed to appear in court before.
He could be a boxer anymore.
And Judge, one other thing, and I know that this is somewhat difficult to say over this particular public forum, but Mr. Salim has some mental health problems. He has been
mental health issues.
Not incarcerated, but he has been an inpatient several times at Grady for psychiatric problems. He needs medical treatment and psychiatric treatment. And the last place he's going to get either one of them is the Fulton County Jail. So I'd ask the court to set a bond on all these charges. A reasonable bond, I think, would be somewhere in the total neighborhood of $50,000.
All right. What's
your
the state?
attorney's asking for
No, the state will be asking for a higher bond
Your
of
state is just
at least
messed up.
$160,000. The state is concerned with the aggravated assault against a law enforcement officer charges, particularly shooting at 2 troopers as alleged in the warrants. I do understand the defendant's history and perhaps his injuries as well, but just given the nature of those kind of allegations. Also, the state is concerned about a series of arrests that the defendant have that are of a similar nature. He was not convicted of that, but the state is concerned by that, and the aggravated battery, which I know has been over 10 years that is on his history. Also, I think the defendant would be a flight risk, as there is some Tennessee and Louisiana history of arrests. But the state is concerned primarily with the shooting at the law enforcement officers.
Yeah, shooting at a cop.
I would ask for no violent contact with law enforcement, curfew, ankle monitor, and no weapons.
I have no problems with those conditions. I do object to the allegations in the warrants. And let me tell you 2 things, and let me tell you 2 reasons why. Number one, there are 2 firearms by a convicted felon. Both of those are at the same time and same place that can only be, the unit of prosecution is 1 unit of prosecution. Number 2, I personally hand filed a motion for a preliminary hearing on June 21st of 2023. I have not yet had a preliminary hearing. I don't believe that the evidence is going to bear out the allegations in the warrant. And I've been wanting a preliminary hearing. I have a right to a preliminary hearing.
Good job,
we haven't
Chris.
had a preliminary hearing since I filed this in June, July, August. I mean, how long does it take to get a prelim with no indictment? So, Judge, I think a $50,000 bond with ankle monitoring, with confinement, except with your usual conditions, would satisfy all of the IALA factors. And at this particular point, we're going to walk into the 90 days. So he's going to be entitled, give him a reasonable bond. Let him take care of his kids and get medical treatment and psychiatric treatment.
This is a great judge. Not great judge.
Anything else from the state?
Judge,
from the state?
Attorney.
Yeah, and I would just address that it appears that there are 2 firearms alleged in the warrants. So I guess I'd have to review the code, but I don't believe there'd be any issue with him being charged, since there's a SCCY 9mm and a Glock 19 9mm, which I'd imagine would suffice for the firearm by felon count.
But there can be only 1 conviction.
All right, let's see. Sorry, this is going to Ted. So we'll have no drugs unless prescribed, no alcohol, no weapons. Stay away from 448 Boulevard Southeast. No further contact with Trooper Jabari Horn, Horne, or Trooper Cedric Ritchie, Riche, unless it's in their official capacity. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Right? If you're going to live in Decatur, Stay out of Fulton County unless you're here for court. See your lawyer. Medical if you have to return to Grady, and employment since I think it's in College Park. I don't know if it's on the Fulton County or the Clayton County side, sir, but if it's make sure you just let them know where it's at and the times you'll be working, okay? And sir, my hat's off to you. If you go seek mental health treatment, that's fantastic. More people should, and I support you in that. So if you need to leave for mental health treatment, you can also do that. There's nothing to be, ashamed of. That's absolutely fantastic. You should be proud if you need help that you go get it. We all should do that. All right. So I got 5,000, 1,000, 1,000, 1,000, 3,000, 1,000. Then I got 100, 30,000, 30,000, 20, and 10. Let me say that one more time. 5,000, 1,000, 1,000, 1,000, 3,000, 1,000, 100 on the failure to obey traffic control devices, then 30,000, 30,000, 20,000, and 10,000. And that ankle monitor.
100,000 or $100?
Oh, on the traffic control devices is $100. Yeah.
Okay, thank you. You said 100, and I'm thinking, whoa. Are you? It's a misdemeanor. What are we doing here?
That was a serious stop sign, right?
Yes. Okay.
Yeah, that's $100.
So what's the total, Judge?
Well, I didn't do the total. I was just writing them down.
Is it around 120?
I think so.
Yeah.
60, maybe. 90. All right. Best of luck to you, sir. Oh yeah, and no driving till your bond is modified. Said you were going over 90 miles an hour. So best of luck to you, sir. No driving till your bond's modified. Best of luck to you. You can leave the booth. Thank you, Mr. Harvey.
At least you gave them a good bond.
I'm leaving the
pun intended. So from there,
you can leave the booth, sir.
The court.
So do we have Jermaine Davis? Any update on Jermaine Davis?
Yes, Judge. I've been advised by staff at the jail that he refused to leave the room to participate.
I think he did that before too, Miss Rondon.
Yes, Your Honor, that is accurate.
He's at no bond on this.
Okay.
So
can we reset Mr. Davis for another date in the future, and I will speak with him at the jail and potentially waive his appearance.
All right. You think 2 weeks, something like that?
2 weeks is fine.
Okay. Are you sure?
It'll probably be the end of the month.
Okay. All right. So it'll be you'll have time to talk to him though, Ms. Rondon. And in the meantime, if you talk to him and he agreed, you may come up with a consent bond. And what about Javon Barnes? Any update on that one?
Mr. Barnes, to be honest, they're short at the jail. They're feeding right now, and they're trying to get him to the booth.
Oh, okay. All right. So we can just go ahead and do so Ms. Flack, you just stand by because they're a little short-handed, okay?
No problem, Judge. Thank you.
All right. And so we can go ahead and do the one bond modification. So that's
$92,100.
Tamika Ali.
The last bond. About.
Miss Ollie is on the Zoom. There she is.
95, 6, 7.
All right. Raise your right hand, Miss Ollie. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
120,000.
Yes, ma'am.
All right. All right. This is the one add-on is 22 CP 214957, cruelty in the first and simple battery family violence. And last time we were here, as I recall, she was at the house with the daughter in violation of the bond conditions. I'd said anything, Bostic? Preach. Wow.
Nothing new to add, Judge.
All right. Go ahead, Miss Rondon.
Yes, Your Honor. The motion filed is a bond modification motion, and we are asking for 2 conditions of Miss Ollie's bonds to be modified. The first condition that we're asking to be modified is the stay away condition. We are asking that Miss Ollie be allowed to reside at the address
those are rare.
Stated in the bond condition, the Atlanta Street, Atlanta GA address, which is the family home. Miss Ollie is undergoing treatment for cancer and does need a stable and good home to be able to participate in her cancer treatments and to recover fully. The second condition that I'm asking the court to modify is the no contact order with her daughter. We are asking for that to be modified from no contact to a no violent contact order. This case was continued from the last time it was on the calendar at the defense's request so that we could make contact with the DFACs because there at one point supposedly was a case in connection with this criminal case. Unfortunately, I have not been able to make contact or receive any response from DFACs concerning my multiple requests to speak about this case. I think what that indicates to me is that if there was an open pending case with the Ollies, that DFACs would have an opinion on this, and that DFACs would like to make their opinion on whether contact or no contact, they would want that to be known to the court. And I think that
That's fair.
Not answering any requests and not being present in court today to give an opinion signifies they don't have one. And so, Your Honor, I would ask for the condition of no contact to be amended to a no violent contact order, and for Ms. Ollie to be allowed to return to the family home on Atlanta Street.
So, Ms. Rondon, since last time she was already living there in violation of the bond conditions, I'm assuming that you had a nice little chat with her. So where has she been staying since then? Because now she's outside. So, I mean, I have to tell you this makes me feel weird, like maybe she's outside of her own house. Maybe she's there, but I would trust what you say.
Yes, we did have a conversation after the last hearing, and she's been staying at a friend's home.
All right, what says the state?
Your Honor, so, and I apologize, Your Honor, so obviously I wasn't here for the last hearing, so if I could just ask a few clarifying questions, would that be all right?
Oh, sure, absolutely.
All right, and Ms. Rondon or Ms. Ollie, the one of y'all can answer this if you know the answer. Who is living at the home, other than the daughter, who else is living at the home right now?
He has a lot of cases, he doesn't know the facts of them off the top of his
Ms. Ollie, I would say that you can answer that question and just repeat the only people that are living permanently in that home.
It's a standard case.
You're on mute,
Ms. Ollie. Ask some basic questions, see if it's okay. And that's how it should be done.
Mom, dad, and 5 children.
Oh.
Okay. So Your Honor, based on that information, I don't have any problem with, well, my one issue, Your Honor, obviously there's a threat to intimidation. The main victim is the daughter. So that would be the one outstanding threat. Ms. Ollie does not have any criminal history. So I don't think she's a threat to commit more felonies. So with that in mind, I don't have any issue with either one of these conditions being modified. I'm not going to object to it, but I am concerned that this may put Ms. Ollie, even with her medical circumstance, in a position to violate her bond condition because there's obviously some issues going on there much deeper than just the altercation.
Well, she's already violated it one time, and I was not happy.
Yes, Your Honor.
I think I was a little more than not happy. So that's fine, Miss Rondon. Just send me the order.
Thank you, Your Honor.
Ms. Ollie, I will tell you this. The main reason that I'm modifying this is because of your lawyer.
Yes, ma'am.
But when a judge, and not just me, tells you to do something, you got to do it, whether you like it or not. I'm glad that you went the right route by getting it modified, but you didn't need to anticipate what was going to happen, okay? Because
I understand.
I'd almost made up my mind that you weren't going back there until the case was over. All right. So we'll go ahead and modify it. No further violent contact. Now, I say if you have any violent contact with it, I'll go ahead and let you know it won't be good because they can violate your bond. Then you'll be back in jail, Miss Ollie. I wish you the best. Hope everything turns out well for you as far as your if your cancer treatment goes. So just think about that before if you ever want to get an argument with, don't do it. Just take care of your health, okay?
Jail. That's got to be the definition.
Best of luck to you, ma'am. Miss Rhonda will shoot me that. And once I sign the order, you can go ahead and make it that she can move back today. You can put it as of today, Miss Rhonda. And so if it takes a day to get in the system, she'll at least be able to go back. Thank you, Miss Ollie. You can go ahead and leave.
All right, thank you, Your Honor. May I be excused?
Yes, sir. Thank you. All right. Are you Mr. Barnes, Javon Barnes? Wave your hand if that's you. Ooh, okay. All right. So this is position 10 now, Miss Black. It's 23 CP 219400. 68 days without indictment, no bond as of 6/16. Unlawful for a person to be employed or associated with a criminal street gang to conduct or participate in criminal street gang activity. Unlawful for a person to commit the offense with the intent to obtain, earn membership, maintain, or increase status in a gang. Unlawful for a person to acquire, maintain through criminal gang activity or proceeds derived from such. Possession of a firearm or knife during the commission of a felony. And armed robbery. Pre-trial.
No prior arrest history.
All right. Go ahead, Ms. Flack.
Thank you, Judge. Mr. Barnes is 18 years old, Judge. At the time of before his arrest, he was living with his mom in Douglasville. He is a lifelong resident of Georgia. His father is present, Mr. Jonathan Barnes. He's present on Zoom if the court would like to hear from him. His mom is also present watching remotely on YouTube. Judge, if he's released on bond, he will be living with his dad, which I think makes a big difference in this case. His father is retired law enforcement and currently is employed as a security industry, but was employed as law enforcement with Georgia's state of Georgia, as well as City of Morrow and Florida Department of Law. He is presumed innocent of these charges, Judge, and I can assure you that Mr. Barnes is not a gang member. But nonetheless, I understand this is not the appropriate juncture to debate the facts in this case, and we look forward to doing that at the appropriate time. He does understand the serious nature of these charges, Judge, and upon his arrest, he was actually pulled over. He wasn't aware that there was an active warrant, but when made aware during this traffic stop, he was peacefully arrested. And in fact, law enforcement, he asked to call his dad. His dad was allowed and permitted to come to the scene to retrieve the vehicle, and so that happened peacefully. And I think that's important, Judge, because if he's released on bond, I'm asking that he live with his dad. His dad and he are very close. He listens to his dad. He's very close with his mom as well. But there's sort of that added layer of accountability that his father is here to ensure that he will comply with any conditions that this court see fit. In addition, because of the serious nature of these charges, Judge, and because he's taken these charges very seriously, he was also evaluated by Gary Davis, who's the CEO and founder of the Next Level Boys Academy. I don't know if the court is familiar with that program, but they do extensive work in Fulton County with people charged with very, very serious charges like this, some even more serious. So since his evaluation at the jail, he has been accepted, and I do have the acceptance letter, which I'm happy to provide to the court. Mr. Davis is also available to log on to Zoom if the court has questions, but he would be required to participate in this program. DA Fonnie Willis is very familiar with this program and has endorsed it. And so I would add that adds sort of an added layer of accountability to ensure that when he's out on bond, he will be living with his dad in McDonough and Henry County. So he has no need to be in Fulton County other than he will be working. He does have an opportunity to work for Penske, which is in South Fulton, if the court would allow that. But he can also be banished from Fulton County because he can attend Next Level Boys Academy, which is in Union City. But if the court doesn't want him in Fulton, he can attend that remotely. Obviously, it's more ideal for him to attend Saturdays. He would be attending that 2 or 3 times a week with Next Level, be given a mentor, doing community service, working on life skills, communication skills, and all of the things that I think are important for somebody as young as he is. If he's released on bond, Judge, he'd be living at 125 Ashton Brook Drive, McDonough, Georgia. Again, we'd ask for an ankle monitor. We are fine with an ankle monitor. There is nothing before the court to show that Mr. Barnes wouldn't comply with any order of this court. Obviously, there's no criminal history. Any other conditions, curfew that the court see fit, we are asking for. So I'm asking for a global bond of no more than $30,000, ankle monitor, and any and all conditions, as well as requiring him to participate in the Next Level Boys Academy.
All right. What says the state?
Good afternoon, Judge. This is ADO come for the state.
Good afternoon.
All right.
Your Honor,
this is
the state's position is that the defendant is a member of a violent gang. This armed robbery was a violent armed robbery. The victim, in fact, was pistol whipped and bled while she was being robbed, and the individuals were armed. The state's position is that the defendant is a member of a gang. he and his fellow gang members robbed the victim twice, the same victim. So the state's position is that for each gang count, we'll be asking for $50,000. Inherent is if you're a member of a gang, inherent in being a member of a gang is that it's a violent gang. I believe he's a member of the Bloods. Inherent is their violence. Inherent is they commit crimes. Inherent is that they commit violent crimes. The state's position is if Your Honor is going to grant a bond, we would ask for $50,000 each on the gang counts. I believe he has 4. That'd be $200,000. And then for the armed robbery as well, we'd be asking for $100,000. That would be $300,000. We'd also ask for no weapons, no replicas of weapons, no association with gang members or known gang members, no gang affiliation, no flying of colors, no social media, and obviously stay away with his co-defendants. I believe his co-defendant's name is Mr. Mbaki. Last name is spelled Mbacke. I don't know if he has been through yet, Your Honor, but we would ask that you have no contact with him as well, and obviously with the victims as well. That's the state's position, Judge.
Judge, if I could just add, we have no issue with no contact with anybody that the court see fit in this case. I would ask though for, I think that bond is excessive. If we're talking about a gang member, that the very office has consented, the DA's office that is, has consented today to a RICO, arguably the biggest racketeering gang case that that office has ever seen for the President of the United States of America. And that consent bond was $200,000 for somebody with multiple open indictments. Mr. Barnes has no prior arrests. This is his first case. And so to ask this court to issue a bond to an 18-year-old kid with no record, no history, with all we have is one simple arrest warrant, not an indictment with multiple counts and multiple co-defendants. To ask this court for a $200,000 bond, I think is just inappropriate and is punitive at this point. So I'd ask for a bond of no more than $30,000.
Oh, that's a great point.
Ms. Oakham, anything else? Did she freeze?
Your Honor, I would note that the RICO charge for the $200,000, he's not a violent gang member. I would just note that for the record, Judge.
I just read that.
I think that's arguable, Judge.
All right, let's see. So, and he's the gang that he's allegedly a member of is Atlanta Blood Gang. Is that correct, Ms. Oakham? Is that what you're suggesting?
Nice, the Atlanta Blood Gang, to be specific, the Inglewood Family 9 Use Blood Gang.
Okay. All right. So, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no social media presence, no wearing your colors, no further contact with any gang members, affiliates of gangs, people wanting to be gangs, thinking they're a gang, the Atlanta Blood Gang or the Inglewood Family Blood Gang or any other gangs. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. Also, stay out of Fulton County except for court, meetings with your lawyers, and employment. But you have to give a schedule. If you're not working there, sir, don't try me. Don't say you don't get a job and then quit it and go back and forth, because the ankle monitoring company, they send a printout and they look over it. All right. So stay out of Fulton County. If anything else, and I think your dad's on here. You're 18. Has he completed his GED? Does he gonna go back and complete his GED?
Yes, Judge. He completed Woodland High School.
Okay. Let's see. Dad, is there anything else? I know you're on here that you need from this court to give you a helping hand.
As much as I joke around without that.
No, sir, Your Honor. Myself and the other half.
All right. So you just got to follow the rules of your dad's house. Okay. If your dad tells you go outside and cut the grass, cut it, go back in, ask him if he likes it. And if he doesn't like it, you go back out and cut it again.
They're giving him another chance.
All right. Until he's satisfied. Anything he needs you to do. And if your dad comes out of pocket any money, you're to reimburse your dad either in sweat equity or dollar for dollar what he has to pay. Because this is not a dad problem. This is a you problem. All right.
And just so I'm clear, Judge, is he not permitted to attend Next Level since it is in Fulton County?
Yes. Okay. And he can attend the program that is called Next Levels, right?
Next Level Boys Academy.
Next Level Boys. You can attend that, but you have to let them know when you're doing it, okay? All right, so all right, 40 on each gang count, 10 on the possession of a firearm or a knife during the commission of a felony, and 40 on the armed robbery. So it's 40, 40, 40, 10, and 40. Best of luck to you, sir. The income honor will be paid for by the county.
Your Honor, that concludes my matter. May I be excused, please?
Yes, ma'am. Good to see you
Thank you,
again.
Judge. Have a good day.
All right, thank you. And thank you,
Your Honor,
Ms.
may I be
Flack.
excused? Thank you, Judge.
Absolutely. Have a good evening.
You
I think
too.
that's it. For sure, right? I didn't miss anything.
Good night, everyone.
Good night, LTs. Y'all are doing great, even though you're a little short-handed.
All right, that's it. It's over.